Okay, we'll bring the order to the meeting of the Public Safety and Crime Prevention Policy and Finance Committee and start out with a roll call.
Representative Cornish.
Here.
Representative Johnson.
Here.
Representative Constein.
Here.
Representative Dean.
Here.
Representative Hertos.
Here.
Representative Hillstrom.
Here.
Representative Howe.
Here.
Representative Lomer.
Here.
Representative Lucero.
Here.
Representative Newberger.
Ready to serve.
Representative O'Neill.
Here.
Representative Quam.
Present.
Representative Rosenthal. Representative Schoen. Representative Ward.
Here.
Representative Winkler. And Representative Zerwas.
Here.
Okay, we have a quorum. Somebody want to move the minutes for March 18th? Representative O'Neill moves the minutes for, what? Is that the right date?
Yeah, but she wasn't here. Have someone else.
Oh, we have to have, you were excused that day. Sorry. Representative Zerwas moves the minutes for March 18th. All in favor say aye. Aye. Opposed? Thank you. Okay, Representative Fabian, House File 307. Somebody want to move Representative Fabian's bill to the General Register? Okay, Representative Zerwas will move House File 307 to be recommended to pass and move to the General Register. Representative Fabian, go ahead and begin however you would like.
Thank you, Mr. Chair and Committee, and thanks, Representative Zerwas, for moving the bill. House File 307 started out as a conversation that I had with a person who had purchased car insurance. They downloaded the insurance app onto their smartphone. They were stopped for a minor traffic violation. They were asked to show proof of insurance. They showed the proof of insurance app on their smartphone, and in that case, the officer would not accept that as proof of insurance. So they wound up having to go to the courthouse with their regular copy and also showed the smartphone app. And at the courthouse, they accepted obviously both the paper, and then they also said, well, that really should have worked. There's nothing that excludes that from being proof of insurance. So based on that, we did some research, and I found out that there are 34 other states that do currently allow for having proof of insurance be in electronic form, whether it's your smartphone or it's your iPad or whatever device you choose to use. So if you take a look at the bill, what we are doing here is we are expressly naming electronic format as provided in 65B. So that is what we're doing there. And then also the bill was amended from its original form in earlier committee so that on 2.24 the use of an electronic device to display proof of insurance does not constitute consent for a peace officer to access other contents of the electronic device. So you can't use it to check to see if they've been doing something else that's against the law. And then also C 2.26, if a person used an electronic device to display proof of insurance, a peace officer is immune from liability for damage to the device unless the peace officer does not exercise due care in handling the device. So in essence, what that means is if you choose to give your electronic insurance verification to the peace officer, you are accepting responsibility for that device being in their possession, should they accidentally drop it or something like that. So that's the essence of the bill, Mr. Chair, and I would happy to take questions.
Okay, members, any questions? Looks like a simple, straightforward bill so far. Any other testifiers with you today? Representative Fabian. Any other testifiers?
I do not, Mr. Chair, no. This has been to 2 other committees and so forth. So
any public testimony? If no public testimony and no questions, closing comments.
Thank you, Mr. Chair. You know, luckily this doesn't impact me. I mean, it doesn't. It does, but it doesn't. I'm not very techie. I'm holding this up just to kind of show off a little bit because I really don't know what it does most of the time. But it's my understanding that in the stop they just need the phone number, the insurance number, and those sorts of things. So it's relatively simple, and it's just a way to get on board with where we are going. So I appreciate your support.
Okay, thank you, Representative Fabian. And Representative Zerwas renews his motion to House File 307 be recommended to pass and move to the General Register. All in favor say aye. Aye. Opposed? Thank you very much. Your second non-controversial bill is House File 305. You can see who would like to move that to the General Register. Representative Newberger moves House File 305 to be recommended to pass and move to the General Register. Representative Fabian, go ahead and begin.
Thank you, Mr. Chair and committee. Again, this is another bill that came to me from a constituent, or the idea did anyway. I've had a number of people contact me in June of 2012 or 13, or not June, but in July or August of 12 and 13, I had constituents who were receiving notification from North Dakota that their concealed carry permit was no longer valid in North Dakota. And that concerned them. I had a couple of students from the University of North Dakota that live on my side of the Red River contact me and say that they were concerned that their permit was no longer valid for concealed carry in North Dakota, which it had been for many, many years. At one time, a ruling was issued by the state of Minnesota that they would no longer be accepting North Dakota's concealed carry permits in Minnesota. And then as a result of that, North Dakota took some action, said, well, if you're not going to recognize ours, we are not going to recognize yours. So what I'm doing in my bill, House File 305, as it currently is just recognizing North Dakota, their permit, so that we regain that reciprocity back with North Dakota on a concealed carry permit, as it had been in the past.
Representative Fabian, do you have an author's amendment in the packet?
Yeah, I believe that's Representative Newberger's amendment, Mr. Chair.
Representative Newberger. Representative Newberger, would you like to move your amendment?
Thank you, Mr. Chair. Yes, I'd like to move the A15 amendment.
Mr. Chair.
Representative Hilstrom.
Thank you, Mr. Chair. Mr. Chair, when do you want us to discuss it? Are you going to adopt it first and then have us discuss it, or do you want us to discuss it first?
I'd rather adopt it first and then discuss it. Get it into the shape.
The author would like it?
Huh?
Get it in the shape the author would like it, Mr. Chair.
Okay, you heard the Representative Newberger moves the A15 amendment. All in favor say aye. Aye. Opposed?
No.
No.
Okay, would you like to, you want to discuss it before you ask some questions?
Well, Mr. Chair, I'm fine with him presenting what it is that he's doing and then have questions and discussions.
Sounds good. Now, which one of you wants to discuss the amendment? Representative Newberger?
And then I think we also have Professor Olson here to testify to that as well.
Representative Newberger?
Thank you, Mr. Chair. What the A15 amendment simply does is it irons out some of the wrinkles that exist, and it brings a level of balance between the two states. The first section of the amendment simply addresses the National Instant Criminal Background Check System that they would use, that would be implemented as it's needed. And then also the second part would be of the amendment here addresses the firearm training and proficiency to the satisfaction of the state's law. It irons out the wrinkles that we've kind of noticed here. The getting into the deep legal weeds, getting into the deep legal weeds is something that I'll defer to the law professor here.
Oh, Mr. Chair.
And members, we realize this is a controversial bill, and I just want to make sure we know that this is not political. We had just as much problem with one party's commissioner as we did with the other interpreting this law from back a few years ago. So this is not aimed at the current leadership of DPS. It's just involves fixing the system that we think has been interpreted too strictly or stringently. Representative Hilstrom.
Thank you, Mr. Chair. Representative Newberger, you talked about it as if it just fixed North Dakota law. In fact, the amendment that you just offered actually makes it apply to all states, not just North Dakota. I just want to make it clear that even though you've said that it applies to North Dakota, the amendment that you're offering actually makes this apply to all states.
Representative Newberger.
Thank you, Mr. Chair. Yes, I was aware that Representative Hilstrom, the primary focus of this is the North Dakota issue, but one of the added benefits to this is that it helps to iron out the wrinkles, like many other states have done, to put us on a balanced ground with the rest of the country.
And we'll hear a testimony, I think, coming up of how many states are recognized and how many are not, and their reasons. Representative Fabian, who would you like to begin with? Mr. Olson?
If you wouldn't mind, Mr. Chair, that'd be good, yeah.
Sir, you want to state your name and organization and go ahead.
Thank you very much, Mr. Chairman, Representative Fabian. My name is Joseph Olson. I'm a professor of law at Hamline University. I am also the chairman of the Gun Owners Civil Rights Alliance. I'm here today speaking only on behalf of the Gun Owners Civil Rights Alliance. A little bit of history. I was the primary proponent of the Minnesota Citizens Personal Protection Act back in 2003 and again in 2005. The language that you see before you in the bill that the Department of Public Safety needs to recognize or list permits that are not substantially similar was written that way for two reasons. One, we expected there to be a very short list, To similar is about the lowest category of comparison that you can come up with. The bill author and her team discussed having it say equal to or greater than. It doesn't say that. They discussed having it say no less stringent than. They did not put that in the bill. They chose similar because a 1917 Spad is similar to a Vietnam-era F-4. They're both aircraft, but they're very different aircraft, but they are similar. We anticipated that there would be 50 states, that the 50 states would have provisions that they wrote that went their way, and that Minnesota would recognize the states that were similar. We anticipated there would be problems with at least 2 states. Washington State requires no training whatsoever and has 300,000 permit holders. Pennsylvania requires no training whatsoever and has about 800,000 permit holders. We didn't think those states would be similar because they have no training. But talking about making judgments about the quality of the substantive law of other states was intended to be eliminated by using the similar language. It hasn't worked out that way. We have a list that doesn't have 34 states on it. It has 11. We have a list that seems to change with commissioners. North Dakota was approved. North Dakota is now not approved. North Dakota wants to be approved. We're attempting to, in this bill, to have similar mean similar. And leave the details to the other states. If they have a background check system or they use the National Instant Criminal Background Check System, that will cover the background check. If they have a proof of firearms training or proficiency standard, we're not going to go to another state and tell them how they have to write their laws. So what this does, this would change Minnesota from recognizing 11 states to recognizing probably somewhere in the neighborhood of 30, which was the number that was originally discussed when similar was chosen as the word to put in the statute. And the comparison is are you similar? Think about driver's licenses. We recognize driver's licenses from all over the place. In Minnesota, we have a whole bunch of restrictions on teenage drivers. I got my driver's license in Texas when I was 14. It was perfectly good in Minnesota, although Minnesota didn't issue driver's licenses to people at age 14. It was similar. A state had looked at my capabilities, a state had looked at my training, a state had made a judgment about me, and we recognized the judgment that that other state had made. Now, the original language attempts to deal with those few situations where a problem might crop up. Most people, we judge them by their conduct. If someone doesn't act out in Minnesota in an antisocial way, the government of Minnesota never comes in contact with them. But what if we had someone who indeed has a permit from another state but who cannot possess a firearm in Minnesota? The carry law has nothing to do with possession. It has to do with whether you can carry it with you when you're in a public place. But we have possession laws, and possession laws apply to everyone who comes to Minnesota. So if someone in Wisconsin brings a modern machine gun into Minnesota, they will violate our law. We have a provision in paragraph B of the original law that attempts to deal with that. If someone causes a problem and comes to the attention of the sheriff, and it's determined that notwithstanding that they have a permit from New York City, they can't possess in Minnesota because Minnesota happens to have one provision that's different from all the provisions in New York State. We can deal with that. The statute was designed to deal with that. Additionally, Minnesota has an unusual provision that allows sheriffs to request revocation of a permit or not give out a permit on the basis that the sheriff makes a factual determination that the person would be unsafe would be dangerous if they carried a firearm under a permit. We apply that to our citizens. Clause C or paragraph C in the statute applies that to those who are carrying here on permits from other states. So knowing that identity is impossible, the word chosen was similar. The word substantially was put in front of it because usually when substantially comes in front of a noun, it's a weakening term. Somehow it got completely misconstrued. And we don't wind up with similar. We wind up with something else. So what we have done is define what substantially similar means. It means you conduct a background check. It doesn't have to be exactly the same as Minnesota's. And the 11 states that are on the list do not one of them conducts a background check that is absolutely identical to Minnesota's. Because they're conducted under different laws by different people using different systems. The National Instant Background Check is a identical check that is done for the purchase of every firearm bought from an FFL holder. And it's the check that we hear everyone running around saying, oh my God, we ought to have universal background checks because the NICS check is so wonderful. Well, we think it is wonderful in that it provides a standard that's uniform. It provides a standard that is the same everywhere. And that ought to be similar enough. It's not identical. It's never intended to have a standard of identity. If we had that, we would actually have no other states recognized. And lastly, the applicant has to demonstrate proof of firearms training or proficiency. Essentially, we have in Minnesota a background check law, and we have a training law. This requires that those who would come to Minnesota and carry a firearm have to have a background check, and they have to have training. It has to be similar. It doesn't have to be identical. It doesn't have to be as stringent as. The statute never said that.
Okay, Representative Hillstrom had a question.
Thank you, Mr. Chair. Professor Olson, you talked about how the National Instant Background Check System was the standard that we should all be using, and that it's the best that you have. So my question is then, why on line 1.26 do you have or? A background check utilizing the National Instant Criminal Background Check System or other criminal and mental health background checks are conducted. So why would you permit some state not to use the National Instant Criminal Background Check System if that is the best system that we have?
Professor Olson.
Mr. Chairman, Representative Hillstrom, that has been a matter of much discussion between the representative and among ourselves, the proponents of the bill. And I think we would welcome an oral amendment that took out or other criminal and mental health background checks. There are 2 states that don't use NICS, and they should. And we shouldn't recognize them.
You want to make an amendment?
Mr. Chair, well then I guess on line 1.26 it should be and instead of or.
Is the author, Professor Olson, okay with that amendment? Yeah. Representative Fabian, go ahead.
Thank you, Mr. Chair. Representative Hillstrom, I think rather than and, we would just, from the comma after the word system on 1.26 through the comma after checks, we would just take that out totally.
Mr. Chair.
Representative Hilstrom.
Thank you, Mr. Chair. Well, Representative Fabian, in the last biennium, I funded $1 million to fix and put our mental health records into the national background check system. Our state was not even doing it well, and we were one of the better states. And so what we found is that we actually had a separate database where mental health background records were placed, that when you got the background check from law enforcement, they were searching. So if one of those databases like we had up until last year existed in the state, I would think we would want people to check that mental health database.
So interestingly enough, the mental health.
Dr. Olson.
Mr. Chairman, Representative Hilstrom, there is a 1994 law that directs the Health and Human Services Department and the Department of Public Safety to share that data by electronic means. That law was never complied with. And the money that you got approved in the last couple of years was designed to fill a gap of non-compliance by Minnesota agencies. If an agency is not complying in another jurisdiction, we probably won't know about it, and we'll really have no way of dealing with it directly. So I think going to the NICS system, which we know exists, we know the NICS system is becoming better by leaps and bounds every year, and has become massively better in the last 3 years because of efforts such as yours. I think it would be better to go with the NICS system than to have someone at the Minnesota BCA delving into the arcane ways in which other states handle data, because we know that they're required to present a lot of it to the federal government. They're required to present, in fact, all of the relevant data to the federal government under the NICS system, and there have been deficiencies in the past, but those are rapidly being corrected.
Mr.
So help me out, where are we at with the amendment? Are you offering an amendment, and where are we sitting?
Well, Mr. Chair, I think it should be "and." I understand the author would like it to be a deletion of the rest. I would offer the and leave the rest. Just, Mr. Chair, one of the arguments constantly around here is that law-abiding gun owners should be left alone, but people who are disqualified because they have mental health record issues or mental health problems should lose their right, and people who are criminals should lose their rights. And so, Mr. Chair, all this really does is say, if you've got a mental health database of people who are not eligible to possess, you should look at it before the state honors the permit in Minnesota. That's what that language would say if "and" is there, and that's it.
And now I need to know what you think about the amendment. Representative Fabian.
Thank you, Mr. Chair. I guess initially I'm a little concerned that with the "and," we would be kind of going back to a system that I'm trying to close, in that now we're opening it up to more interpretations over at DPS, similar to some of the statements that have been made with regards to, and what started this discussion was the North Dakota issue. And Representative Hilstrom, sincerely, I'm willing to work with you on this as the bill moves forward. If we can come to some sort of an agreement, I really am. But I don't want to take this back to a possible situation from where I'm trying to get away from to get to here to allow for, I'm just going to say, more interpretation at the Department of Public Safety. And I respect what you're saying, but I'd rather not try to refix it, on the House floor. Mr. Chair, I'm not exactly sure what your intention is with this bill.
My intention is to do what you want with the bill. I just need to know a clear signal. I support the bill. So, Representative Hilstrom, what would you like to do?
Thank you, Mr. Chair. So Representative Fabian, all I want to tell you is that, you know, when you put a bill like this, what you're doing is you're making it easier for people from other states to carry a gun in Minnesota, right? That's your goal in doing this bill. But what you're doing is you're making it easier for people in other states to carry a gun when it's harder for Minnesotans to do it than what you're putting in the statute. So you're saying if you live in Minnesota, you got to go through all these things to get your permit. But if you live somewhere else, we have a lower standard for you to bring a gun to Minnesota. So I'm looking at the statute here of what we require for background checks for folks and to get a permit to carry, and it says the sheriff must conduct a background check. And what we require them to check is they must check MnSIS, Minnesota Crime Information System, and they must check the National Instant Criminal Background Check System, at least yearly to ensure continued eligibility. And so what you're saying by deleting that or mental health background is that if you live somewhere else, we don't care if you have a mental health database problem, you can come on and bring a gun, but Minnesotans, you can't. So you're making it easier for people who live somewhere else to bring a gun to Minnesota than Minnesotans. And so that's what the language says of what you're doing. And I just want to make that clear. So, you know, do whatever you want. I only offered the and because I thought you really wanted to do a full check if you're going to check. I don't think you want people to not have to check MnSIS NICS at a minimum. You make it much harder for Minnesotans.
You offer an amendment then?
Yes, Mr. Chair, and.
Okay. Representative or Mr. Olson, Professor Olson, go ahead.
Mr. Chairman, Representative Hillstrom,
And Representative Cohen will have a question. Go ahead.
Right. Okay. Sorry. The Minnesota check of the MnSIS system, the data in the MnSIS system that needs to be in the NICS system is by virtue of your efforts a couple of years ago in the NICS system. So, in fact, by checking the NICS system, a Minnesota sheriff would be checking both systems. That's, we believe, the situation in the vast majority, in fact, all other states. There are 2 states that don't use the NICS system, and that's why the or other criminal or mental health check language was in here. We are willing to eliminate that language and let those states deal with their problem and not bring it to Minnesota. So the NICS system has the mental health data. If a state has mental health data, they're transferring it. That's computerized, reachable. It's going to the NICS system. You know, I couldn't have said this for sure 10 years ago, but today, through your efforts and the efforts of similar legislators in other states, the NICS system is pretty much the gold standard. And rather than having a system where
Members, during the pause, I just want to announce that we're going to be coming back here at, we'll never get done today. We're going to be coming back at 15 minutes after session and go until we're done with all the bills. So go ahead, Professor Olson.
Actually, I just got a note. Oklahoma is the state that doesn't do the NICS check, and Minnesota recognizes Oklahoma. So we could leave it exactly the way it is. I don't think it needs an amendment.
Representative,
the states that don't do NICS checks, the one state is Oklahoma, and it's recognized. There may be another outlier out there.
Representative Schoen.
Sure he's done.
To the amendment.
Mr. Chair and Representative Fabian, so, and I know, or Mr. Olson, wouldn't we want our DPS, BCA to find out whether other states are having separate databases for their mental illness records at this point in time? Because, I mean, my number one issue when I focus on Second Amendment issues is the difference between, as Representative Hillstrom pointed out, those that lawfully possess and those that should be forbade because of various reasons. Yes. So you say it's arcane task, I believe was the words that you used, but why wouldn't we want them to undertake that, to find out who keeps separate databases if we're going to commit this?
A short answer if you could.
Mr. Chairman, Representative Schoen, Representative, the bill author, you know, if it said and after checks it said if any, it would probably be acceptable. It would be acceptable to us. I don't know about the bill author.
Or, Mr. Chair, if a separate database is, I know we're kind of, I mean, if he's going into the, I talked to Representative Hillstrom and Mr. Diebel, but, I mean, if we can clarify that if a separate state has a separate database, that those databases actually get checked.
Representative Hillstrom.
Thank you, Mr. Chair. In consultation with Mr. Diebel, maybe if available, because that tells you whether or not there is one or isn't one. So if you add the word if available.
Mr. Chairman, Representative Hillstrom, at least to Gopher, that would be acceptable.
Mr. Diebel, will you read the amendment so everybody can understand it then?
Mr. Chair and members, on line 1.26 of the amendment, the A15-0286 amendment, you would delete or and insert and after the second comma, you would insert if available, comma,
And Representative Fabian and Professor Olson, make sure if that's okay, if you want a short huddle or whatever. Is that acceptable?
Mr. Chair, I accept Mr. Olson's judgment. He says it's fine. I take it.
Okay, Representative Hillstrom has offered the amendment, and I think everybody has understood it. And Representative Fabian, you're okay with it?
Yes, Mr. Chair.
Okay, all in favor say aye. Aye. Opposed? Okay, motion carried. Representative Dean, I've got on here.
Thank you, Mr.
Representative
Chair.
Considine, did you have your hand up too?
Representative Dean was first.
Okay.
So one of the problems that I've heard with the NICS system, of course, is federal government can't require a state to participate, quite frankly, because of the 10th Amendment that allows states the opportunity. And one of the conversations we're engaged in right now is the difference between states. So in many ways, the U.S. Constitution allows the opportunity for differences within states. And what I think this amendment does is try to homogenize states from Minnesota's point of view, in that all states, whatever they do is fine with us as long as they meet the few requirements. I like the additional changes that just took place because I'm looking at the number of mental health records provided to NICS in the United States, and there are some states that provide only 25, like Oklahoma, while other states like Kentucky, probably similar populations, 15,000. So it's real clear that some states do a really, really good job of reporting mental health records to the NICS system, whereas some states do a really, really bad job. And I think in looking at using the NICS system as sort of a gold standard, and I believe that was your word, I think we begin to sort of create this fallacy that somehow the NICS system is really, really good and we should just look to it and accept any state that has any NICS record as a possibility. So I would just make that comment that we really need to be careful the road we go down, and we really need to know what it is we're saying. You know, we do have states like Texas that have 241,000 records that are reported. And of course, our state, we have more than 45,000. But Montana has 3, Wyoming has 3, North Dakota, the state that we originated with, has 394. So I think it's important to know that a state's participation in NICS is not required. in that not all states participate at the level as other states, including at the level of Minnesota. And if you'd like to respond.
You didn't respond unless you really feel it necessary. It's not a question. Go ahead, though, if you make it short, please.
Mr. Chairman and Representative Dean, may I ask what was the date of the information you were reading to us?
Representative Dean.
This is as of November 30th, 2014.
Mr. Olson.
NICS is in the process of expanding its databases tremendously due to legislation such as that was put forward by Representative Hillstrom. There is tremendous pressure on the states to cooperate with regard to mental health records. There have been laws passed in a number of other states requiring the transmission of those records to NICS. And I believe that Representative Hillstrom's addition of the word add would catch all of that. And we've, you know, I live here too. I have the same interests that Representative Schoen has, the same interest that you have in seeing that people who are carrying firearms on their person in Minnesota are generally good folks. But I realize that, and I want that to happen. And that's why we accepted the change. We believe it will improve things.
Mr. Chair.
Representative Dean.
Thank you. Yeah, we all have the same interests, but we have different responsibilities in this room. And that's why it's important that we ask these questions and understand that we're being asked to make decisions relative to the law, and you're not, quite frankly.
Yeah. Representative Considine.
I just want to make sure I understood the amendment, Mr. Chair. And the result of the amendment will be that mental health records will be checked all 50 states if they're available. Is that correct?
One of you folks want to answer that?
I see, Mr. Chairman, Representative Considine, I see Representative Hillstrom shaking her head up and down. So, yes.
Okay, I just want to make sure that that was the case.
If they're available.
Okay,
Thank
any
you.
other questions right now? If there's no other questions, any other testimony from anybody? We got a list of testifiers, right? Bring up whoever you would like. Unless, Professor Olson, were you done?
I'm done, yes.
Okay, bring up your next witness there, Representative Fabian. Anybody else? Okay, if there's nobody else, do we have a list? Susan Sheridan Tucker, Executive Director of the League of Women Voters. Welcome to the committee. If you could state your name and title, even though I already have, go ahead.
Okay. Mr. Chair and members of the committee, thank you for the opportunity this morning to testify. My name is Susan Sheridan Tucker, and I'm the Executive Director of League of Women Voters, Minnesota. For the past 95 years, we have been a good government organization, and it's our mission to encourage informed and active participation in government. League does not support or oppose any candidate or political party. Along with protecting the right to vote for citizens, we support the right of all citizens to know what their government is doing and to participate in government decisions at all levels. So in other words, transparency and citizen participation are top priorities. And while this is time-consuming, in the end it leads to better decisions and better public policy. So today I'm here to express our opposition to House File 305. League of Women Voters' position on firearms is to protect the health and safety of all citizens through limiting the accessibility and regulating the ownership of handguns and semi-automatic assault rifles, and support the allocation of resources to better regulate and monitor gun dealers. We also support restrictions on the sale, possession, and use of firearms by private parties in the state of Minnesota. So today we come because it's unclear to us why we would want to pass legislation that essentially would give any state more power than the state of Minnesota. It seems to question our own state sovereignty and our own state rights. And even with the amendment as it stands, the word, removing the word substantially, we believe, actually dilutes Minnesota's power. And we're not really ready to regulate and subjugate our state sovereignty at this point. So we're asking that substantially be put back into the amendment because we do think it's a significant dilution of Minnesota's intent to have stronger gun and carry permit laws. So with that, I thank you this morning for this testimony.
Thank you much. Don't see any questions. Appreciate it.
Okay.
Ms. Martens from Citizens for Safer Minnesota is up next. Or Protect Minnesota, I'm sorry. Ms. Martens? Ms. Martens, did you change the name of your organization? Did it used to be called something else?
Mr. Chair, we at one time were called Citizens for a Safer Minnesota Education Fund, and we're now called Protect Minnesota.
Okay, sorry about the misnomer there. Go ahead and introduce yourself and begin, ma'am.
Okay. A lot has changed since yesterday. I'll just introduce myself. My name is Heather Martens. I'm Executive Director of Protect Minnesota. We represent a network of 15,000 Minnesotans who are concerned about gun violence and wish to use a public health model in preventing gun violence. We are also nonpartisan, and we have also expressed our opposition to HF 305, and I have a statement about that which I will also adapt because of the introduction of the amendment. I, too, was here in 2003 when Minnesota passed a law requiring law enforcement to issue permits to carry loaded guns in public to just about anybody who wasn't prohibited from owning a firearm. There was a push at that time to recognize permits from other states, but at that time it was recognized that it's a bad idea to give our sovereignty away to another state. Instead, the current system was set up. The Bureau of Criminal Apprehension annually reviews the laws of other states, recognizing that laws can change from one year to the next. I see in the amendment that there's no requirement that the BCA review, that there's any adaptation for that. This bill would roll back that ability of the Bureau of Criminal Apprehension to see if a law is substantially similar. So I, too, would say it's important to include substantially. And a couple of differences between North Dakota and Minnesota came up when I was doing research about the difference between the two states. One is that North Dakota issues permits to 18-year-olds. Minnesota issues permits only to people who are 21 and older. And there was a lot of debate and discussion about that in 2003. And it should have been settled at that time, but I see that this could bring up this whole issue again. And I'd like to cite, as I did in the memo to you, that it's actually a very important difference. If you are issuing permits to 18-year-olds in other states, you're issuing permits to a population that has a much higher rate of crime commission than other age groups. I'm going to cite something from the Johns Hopkins School of Public Health about that. In an examination of the background and legal status of gun offenders incarcerated in the 13 states with the weakest standards for legal firearm ownership, the largest segment of offenders who would have been prohibited in other states with stricter standards were those who were between 18 and 20 years of age. So essentially what you're doing is you're allowing 18-year-olds from other states to come in and carry their guns here. And that is a substantial risk to our public safety, in my opinion. The other difference that comes to mind is rules about domestic violence restraining orders. Those vary from state to state. In Minnesota, we worked really hard. Representative Schoen was involved in that very deeply to ensure that people with domestic violence restraining orders could not get guns. But this is not, there's no reference to that in this bill. there's no way to exclude people who have domestic violence restraining orders from other states unless they are also prohibited in that other state from owning a firearm. So the scenario comes to mind that a person from another state who would be prohibited from owning a firearm in Minnesota because he has threatened his estranged spouse could come across the state border and not be stopped because his permit is valid in another state. I think that needs to be considered as well. And I would also like to add that the NICS check, I'm glad that it's improving, but it's still the case that our local background checks that are conducted turn up the vast majority of prohibitions on owning a firearm in Minnesota when those checks are conducted, and that's also to be considered. And those are the main points I would like to issue at this time.
Thank you, Ms. Martins. I got a question from Representative Johnson.
Mr. Chair, members, Ms. Martinez, I just want to clarify one thing that you stated about domestic abuse and restraining orders. Federal law prohibits persons that have been convicted of domestic abuse or have a restraining order to possess any firearm.
Ms. Martins.
Mr. Chair, Mr. Newberger. Sorry, Johnson. The definition of domestic partner varies from state to state. So in some states, it's recognized only if the couple is married, and in other states, that is not the case. There's no accounting for that distinction in this bill. So if someone complies in one state and not another, there's no way for Minnesota to recognize that.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. I actually have a question for Mr. Olson based on the testimony that was just given. Can we get Mr. Olson?
Okay, well, just a second. Are you done then? Nobody else has any questions for Sir Martins? Okay, thank you very much. And Professor Olson. And what we'll do in this, if we want to come back, we'll do the same thing as we did before. We'll allow both exactly the same time for comments in the end. If your supporters want to mention anything, and then we'll bring Mrs. Martins or whoever she would like to bring up again. Professor Olson, the Representative Hillstrom has a question.
Thank you, Mr. Chair. So I've been consulting with Mr. Diebel as he has a copy of North Dakota's concealed weapon license packet here that's put out by the Bureau of Criminal Investigation. So that's what I'm referencing. So based on Ms. Martin's testimony about 18-year-olds, I asked Mr. Diebel if he could help me find in this regulation whether or not a Minnesotan who's 18 could get a permit in North Dakota and then legally carry a gun here if they're not currently eligible under Minnesota law. And their requirement is that you only have to be a lawful United States resident to apply for a permit in North Dakota. Therefore, a Minnesotan could apply for a permit in North Dakota. So then I asked, okay, so there are two classes of licenses in North Dakota. There's a Class 1 and a Class 2. So I asked, okay, so you're only eligible if you're under 21 to get a Class 1? You're only eligible to get a Class 2 license in North Dakota if you're under 21. So then I wanted to know if this would allow us to carry, if those students, young people, to carry in Minnesota a Class 2 license under this language. Their only requirement for a Class 2 license is an applicant for a Class 2 license must successfully complete an open book test based on this manual. So my question is, for you, is based on what this says and the requirements for people between 18 and 21, could all Minnesota students or all Minnesota young people between 18 and 21 who are not eligible to possess a firearm in Minnesota as a permit to carry, get a permit to carry in North Dakota and carry it here in Minnesota?
Professor Olson.
Mr. Chairman, Representative Hillstrom, the permit that North Dakota issues, which requires the background check and I believe which would meet the language in the amendment, is their Class 1 permit. They set up a Class 1 permit specifically to meet Minnesota law. The Class 2 permit in North Dakota, and I'm no expert on North Dakota law, doesn't require training. The Class 1 permit does. The Class 2 permit doesn't require the same level of background check that the Class 1 permit does. So the permit from North Dakota that would be recognized would be the Class 1 permit.
So,
I mean, that's why we leave.
Background check, different training.
That's why we leave the DPS in the loop, because there are going to be situations where other states will have permits that are not that don't qualify under
Mr.
the
Chair.
standard. So North Dakota has 2 permits. One would qualify, one would not.
Mr. Chair.
Representative Hill.
Thank you, Mr. Chair. So does any other state allow 18-year-olds without this 2-class?
Oh, I'm sure they do, yes. Just like Mr. Chairman, Representative Hillstrom, I'm sure they do. Just like I drove in Minnesota when I was 15 on my Texas driver's license that I was issued at 14. And I don't remember what the Minnesota law for getting a Minnesota driver's license was in those days, but it was greater than Texas.
Well, Mr. Chair.
So we recognize driver's licenses that have age limits.
Well, Mr. Chair, Mr. Olson, the difference is you can't get a Texas driver's license when you live in Minnesota. You can get a Minnesota permit to carry if you live in North Dakota, and you can get a North Dakota permit if you live in Minnesota. That is currently allowed under the law. So my question really is, what I don't want is I don't want people gaming the system. Right, whatever system is put in place, right, and whoever has the votes is going to determine what that system is. I understand how this process works, but I believe that whenever somebody's going to put a system in place, you actually have to make sure that it does what it is that the testimony says it's going to do. And so I really want to find out, I didn't really know about this gap, right, the difference between the 18 and 21-year-olds. That was not clear to me. So the question then becomes, so okay, so now I'm an 18-year-old, and I live in Minnesota, and I want to get a permit. I mean, I'm not, but if I were, and I want to go, I'm going to go to Florida on vacation or whatever, I'm going to do whatever. Can I go take the training in Florida, get that permit, and then be eligible to carry a firearm legally in Minnesota? Because there's these sentences, line 1.11 and line 1.12, notwithstanding paragraph A, no license or permit from another state is valid if the holder is or becomes prohibited by law from possessing a firearm. So under Minnesota law, you can't have a concealed carry permit if you're between 18 and 21. So do those kids, those young people now between 18 and 21 get to carry legally here, or do they not?
The
That's a question.
you said kids?
Well, if you're
The ones
between
fighting
18
in
and 21.
Afghanistan now, you mean?
Well, Mr. Chair, I want to know if we're making them felons.
Okay, Professor Olson, go ahead.
Mr. Chairman, Representative Hillstrom, could a person over the age of 18 and under the age of 21 go to Oklahoma, which Minnesota does recognize, and I believe Oklahoma's permit age is 18, get a permit in Oklahoma and carry on it in Minnesota? Yes, today they could do that. They've been able to do that since 2003. What paragraph B deals with is possession. So rules with regard to possession of firearms age out at 18. So Minnesotans who are 18 or over can possess rifles, pistols, and shotguns. They can't get a permit in Minnesota. If they're willing to travel to Oklahoma, they could get a permit in Oklahoma and carry in Minnesota. And that's always been true, and that's always been true under under states that I believe Minnesota recognizes. I mean, I don't have all 50 of them in my head.
Representative Lucero.
Thank you, Mr. Chair. And Professor Olson just made the point that I was going to make, or he touched on it, and that was, in Minnesota, current law allows an 18-year-old to purchase a long gun. And if somebody, as a law-abiding citizen, and if somebody was going to commit some illegal act with a permit to carry, they're not going to go through the hoops, I wouldn't think, to go to North Dakota to obtain the license, to be able to come back here and carry a permit. Since an 18-year-old can already purchase firearms in Minnesota, as a law-abiding citizen, they're not going to do it. So I think it's a fear that's unfounded.
Representative Howell first.
Thank you, Mr. Chair. And I just wanted to maybe have Mr. Deeble give us all what the, just really short, what the distinct differences between North Dakota 1 and North Dakota 2 carry permits are like, so we all have that availability of that information, because I didn't realize there was a difference. I'd like to know what the difference between the two are.
Well, Mr. Chair, if I could answer Mr. Representative Lucero before we go off down another path.
Go ahead to that point.
So, Representative Lucero, no one has ever accused me of being hysterical when it comes to guns. And I think that you saying that I have unfounded fears is really an inaccurate and unfair representation of the questions that I ask. I think everyone in this room knows that I ask tough questions on all of these issues. And when it comes to fear, that's not me. So I just wanted to put that on the record and think that your characterization was unfounded.
Representative Lucero.
Mr. Chair, and thank you. It wasn't my intent to say that you were espousing fear. It was this concern of going to North Dakota, I believe, is an unfounded concern. So.
Mr. Chair.
Representative Hillsborough.
Thank you, Mr. Chair. Well, Representative Lucero, I haven't even said my position. I'm just trying to do a fact-finding for everybody here. I mean, I would bet if you asked most people that were sitting in the audience, they didn't know the difference between 18 and 21 between Minnesota law and North Dakota. And so right now we're still fact-finding. You'll know my opinion later.
Representative, let's see, Mr. Diebel, you were going to explain the difference for Representative Howe, or you want? Yeah.
Mr. Chair and members, according to the manual that Representative Hillstrom referenced earlier, the testing requirements for a Class 1 license permit to carry in North Dakota include participation in a classroom instruction that sets forth weapons safety rules and the deadly force law of North Dakota. 2, successfully complete an open book test, which was the same language referred to as for the Class 2 license. 3, demonstrate familiarity with a firearm. 4, successfully complete a certified proficiency parenthetical shooting exercise. And there's an explanation as to what the standard is for evidence of familiarity with the firearm. If the committee's interested, I could read that, but it's 3 paragraphs.
That's good. Representative Hall.
I was just looking for what's the differences between 1 and 2. So if that's what 1 is, 2 is just what Representative Hillstrom read to us before?
Mr. Diebel.
Mr. Chair, Representative Howe, members, yes, the 2 only requires the open book test based on this 50-some page manual.
Okay. Representative Holland.
Thank you. And so then an 18-year-old can get a 2, but you got to be 21 to get the 1?
Mr. Diebel.
Mr. Chair, Representative Howe, that's correct.
Got it. Okay, and Representative.
If I could just follow up real
yeah,
quick.
I got your name in the list.
No, this is specific to this.
Yeah, but you were next anyway.
Oh, okay. Well, so as I'm sitting here thinking and I'm listening to this, if I have a level 1 concealed permit in North Dakota, I can conceal and carry, right? And if I have the 2 and I'm 18, I can do the same thing. What type of restrictions are put in place, if any, for the different classes of the permits?
Just so we all understand, we just have a philosophical difference. If it was up to me, I would have passed my bill of guns on campus, and 18-year-olds would have been able to carry because they're able to fight in wars and kill people and defend us. And so we're just all over the spectrum on this. And I sure realize, you know, your interpretation with this, but, and so we can go on about this, but now your question was the differences. What's your specific question?
Well, my specific question is regarding the Class 1 and the Class 2, and what type of restrictions, if any, are put in place with the Class 2, because I'm trying to understand that if we pass something like this relative to North Dakota and other states that might have different classes of carry permits, then now all of a sudden in Minnesota, we've created several different classes of carry permits by this similar reciprocity that's in place. Should DPS say that these are similar and thus they'll be granting? Now, you know, DPS, and we'll ask them to come up at some point here, they could say, well, if they have two classes of concealed, they're not similar because we don't have two classes in Minnesota. Boom, you're done. So, I mean, as we begin to think of sort of the nuances of what we're doing here, these are all things that I think need to be considered.
So your question, who would you want to answer your
well, if Mr. Debo could answer what type of restrictions are with the Class 2 permit versus Class 1 in North Dakota.
Mr. Gavel.
Mr. Chair, Representative, according to the manual, the holders of a Class 1 and Class 2 North Dakota permit to carry have the same rights within the borders of North Dakota. But the manual goes on to say that several states do not grant reciprocity to many holders of Level 2. So to Professor Olson's point, that there are states that recognize the Class 1 but not the Class 2 because of the increased training and testing requirements imposed upon Class 1 holders.
Thank you, Mr. Chair, and to the author. Is there anything in this bill that differentiates states that have different classifications?
Mr. Olson? Professor Olson?
Yes, Mr. Chairman, Representative Dean, it's primarily the proof of training or proficiency that's on line 2.1. Some states have what they call constitutional carry, and anyone who has never been convicted of isn't a prohibited person can carry. There's no training requirement for that. There's no background check for that. Those people can carry in Arizona all they want, concealed or openly, but they can't carry in Minnesota and they can't carry in other states. Arizona, like North Dakota, has a permit system for Arizonans who wish to go through many hours of training and acquire a permit, and they're in. So actually, they used to have 16 hours of training. I used to have an Arizona permit, and it was, you had to go through a background check. You had to be fingerprinted. You had to do all sorts of stuff, and Minnesota wouldn't recognize it. Even though we had the training, we had a background check, we had everything going with it. That kind of permit from Arizona would be recognized under this change in law. And there are other states that are in the same position. It's not just North Dakota. There are other states that have different classes of permits, but the only permit that would be recognized would be the permit that was the result of a background check and training. And that's usually the difference between the two classes of permits.
Representative Dean.
So, Mr. Olson, so I'm not sure you really answered my question because I was asking specifically in the bill if it's called out for states that have different classification of permits that Minnesota would then have to go through a process of determining the similar training requirements and the similar requirements to receive that permit to determine if we would then accept that as reciprocal. And then my next question is, and I think there's been some discussions, where do we draw the line between similar? Because now it's similar, it's not substantial similar. So, I mean, you can make an argument that if one state requires 2 hours of training and we require 20 hours of training. Well, we both require training, so that's similar. So I'm curious how this bill is able to differentiate between different classifications in other states and Minnesota where we don't have different classifications.
Representative Olson, I've just been notified that the basement hearing room has been reserved for us after session, so we'll go there after session. Professor?
Mr. Chairman, Representative, the answer to your first question is no, which I think means basically Minnesota will look to see if they have a NICS check. Yes. They will look to see if they have if they have other checks available. Yes. Minnesota will look to see whether they have a training or proficiency requirement. Yes, no. Minnesota does not get involved in the nuts and bolts of the training requirement because it's a training requirement that satisfies the other state. And the same thing with NICS. NICS is a federal program. It's whatever it is, and Minnesota is not going to make it different. So it becomes a much simpler task for the Department of Public Safety.
Representative Dean, I'll give you one more shot at it, and then we're going to move to Representative Schoen.
Okay. Thank you, Mr. Chair. And Mr. Olson, so I'm really trying to understand, you keep bringing up NICS and, you know, the utilization of NICS. I understand that when you're purchasing from a federal firearms licensee, you then go through that background check. And I've commented earlier about how some states are better in participation than other states. And, you know, the thing that I'm struggling with is we currently have DPS that goes through a process of determining whether or not another state is substantially similar to Minnesota, and they make that determination. Now, I understand that, you know, what this is trying to do is trying to add clarity to what that is versus some subjectivity. But as I'm sitting here and I'm thinking about 50 different states, and I'm thinking about 50 different requirements for permit and all those other things, that really there's no way. Well, I guess my question to you would be, is there a way that we can write this legislation so that it covers all the 50 states that we would say have similar or stricter requirements in Minnesota, and at the same time cover other states that have more lenient requirements as far as receiving a permit? Do you think it's possible to get to legislation that's able to cover all of those states?
Sounds like a real close yes or no answer, Professor Olson.
Yes, I believe we did that in 2003, and I believe this legislation will make it clearer.
Representative Schoen.
Thank you, Mr. Chair. And Mr. Chair, I guess what I'm trying to, I think what Representative Hillstrom got glossed over, she was asking questions based on, are we going to create a further problem with this law by creating felons or making someone commit a felony? And that was one question I'm not sure I heard, if we actually are going to cause problems for some individuals. And then when you bring up the fact of saying, you know, well, you know, we've got 18 to 21-year-olds going over to Afghanistan to fight. Those highly trained people, I don't have a problem with those folks. I mean, we all appreciate their service. But the fact is do we have someone that's not serving our country, that's highly trained? Are they going to be able to go to North Dakota, take a 50-answer test, and then come back to Minnesota? And so those are the questions that we need to dial down and make sure that those are specifically answered. Are we making the standards looser by doing this? If not, then let's move on. But I want to make sure that what Representative Hillstrom said or mentioned in passing there, that we're not causing more problems for individuals like those 18 to 21-year-olds that are fighting in Afghanistan. Are we going to cause more problems for them or not? If there is something that we're missing here, because there's a lot of questions that are being asked here that are kind of like, well, we keep going back to, well, more people are putting stuff in the NICS system, and we're not getting the questions answered. So I want to make sure that those two, or at least that one, are we going to create problems for any individuals that we shouldn't create problems for?
You want that question answered?
That would be nice.
Professor Olson, are we going to create problems for people that we shouldn't be creating problems?
Sure, that'll work.
Go ahead.
In my opinion, no. When I travel and I use my permit in other states, I understand that I have to be able to possess a firearm in that state and able to carry in that state, and the permit only answers half the question. There are a number of websites that gun owners go to that have the full information, and there are 1,000 other websites that refer you to that one. So, yes, people look. They do check.
Okay. Representative Fabian, did you have a comment?
Thank you, Mr. Chair. You know, full disclosure, folks, I don't own a handgun, okay, and I don't have a concealed carry permit, obviously. I do own several long guns, shotguns, and rifles. I've talked to many, many people who have concealed carry permits. When they take the class, they are told very emphatically that it is your responsibility to make sure that you know what the rules are in the states that you're traveling to as well. So, am I correct on that?
Mr. Chairman, Representative, yes.
Thank you. Okay, Representative Considine.
Actually, Mr. Chair, my question is for you. Are we going to provide and fund training for Minnesota law enforcement officers on North Dakota's rules?
I have no idea. I know that we have policies regarding each department on their own policy and how they treat people with permits to carry or what to check for, but I have no idea. Representative Schoen, do you know of any law enforcement agency that trains anybody on North Dakota rules?
Well, Mr. Chair, I mean, they're not allowed to have North Dakota permit wouldn't be valid here because of the standard of training differences. And so my back to my question on that was, is an 18-year-old with a permit from North Dakota that comes into Minnesota now, if we do this, are we going to make them a criminal in Minnesota? Because the standard in Minnesota is 21. Are we going to keep the standard of 21? Or is it if you go out of state, you can be 18? I mean, this is not anything to do with long guns. You can buy a hunting permit. We can go hunting in North Dakota, and you can take your kids there and buy a hunting permit. And that's different. I mean, if you're going to hunt ducks or pheasants or anything, that's not the same as a carry permit.
We'll get back to Representative Considine, but I think the short answer is if we accept another person or a state's permit or recognizes it, then they can carry here, I would imagine. So if there's another state that have different regulations, but we accept it anyway, like we do now already, and some of these states aren't identical, if we accept their permit, then when they come here, then it's valid.
And if that's the case, Mr. Chair, then that is one thing that, I mean, Representative Considine does make a good point. We'd probably have to have, it would be good at least to have an website. I mean, we can look that up to say who is acceptable, but maybe what some of the guidelines are that make that, and if they have it, they have it. If it's valid, it's valid.
Well, yeah, that's true, but we've gone now since 2003, basically without that website, and we have all sorts of,
Mr. Chair, the DPS maintains who we have reciprocity with.
Oh, you want to expand it to what?
I'm just saying if it's that's going to be, we just need to make sure that those things are in place. If we're accepting if there's certain states that we still aren't going to accept under certain conditions, we'd want to make sure that within this bill or any changes that information would be available so I can pull it up on my smartphone if I'm in the car to say, I'm glad you have an Arizona permit to carry or whatever it is. What does that mean in Minnesota?
I got you. Representative Considine, did you have more?
Yeah, I guess I think we are putting a lot of law enforcement officers in a very uncomfortable position, especially as it pertains to the two different licenses in North Dakota. I mean, we're going to have to provide some training or at least some sort of informational stuff to let them know that there are differences. I mean, I didn't know there were two differences until now, and I don't think most of us did. I also didn't know that 18-year-olds in North Dakota could carry. So if we're moving forward on this, we're going to have to provide some training and some information to law enforcement people all over Minnesota. Otherwise, we put them in a position that I think would be very uncomfortable for them.
I'm a little confused by the question that we've already got a myriad of different regulations in different states that carry here. So why would this bill make us change anything right now? We've already got people that carry here of all ages and sizes and from different permits from other states.
Well, again, I wasn't aware of the two-tiered system in North Dakota. And again, I don't think, I would be willing to bet money that 90% of our peace officers aren't either. And so if they're stopping somebody and saying, you know, trying to enforce the law, it'd be nice to know that they're on solid footing and we're not putting them in, again, a position where it would be very uncomfortable.
Mr. Chair, could we have, Mr. Chair?
Where's that coming from?
Me over here.
Yeah.
DPS is in the room. It would be great if DPS could come down and speak to the process that they currently go through and how this amended bill would actually change their process.
I want them to wait until, we plan on calling them down, but I just want to wait until we get through a couple more things here.
Okay.
Mr. Rothman, do you have an answer to that question?
Mr. Chairman, Representative Dean, Representative Considine, members, that system is already in place, and that system doesn't change at all with this bill. The Department of Public Safety also already has the responsibility since 2003 to maintain a website which lists the permits which are and are not valid in Minnesota. If you look on the screens up here, this is the current DPS website that maintains that list, and I've blown it up a little bit so you can only see a few at a time. But as you can see, here are the 15 states that are currently recognized. After this bill becomes law, as I'm confident that it will be, and the number of states increases on this list, the DPS will be required to add those states to this list. This is the list that law enforcement officers throughout the state use if they encounter somebody and they show a permit from another state. This list is their guide as to whether that permit is valid in Minnesota. And in this case, the list would simply say North Dakota Class 1 or 2 permit, or however it came down.
Okay, Representative Hilton.
Thank you, Mr. Chair. So based on that testimony,
Representative Johnson.
so if you stop someone in Minnesota who has a permit to carry, you actually can search the database and find out if the permit they're carrying is for real or if they just made it up on their computer. What happens with these out-of-state permits? Does Minnesota then get access to their database of who has a valid permit so that Minnesota then can just search the database to confirm that the person you have in front of you with Alaska's permit actually is in the database with, I need new glasses, sorry, that they're in the database and their permit is actually valid?
Mr. Rothman.
As has been the case since 2003, the law enforcement officer looks at this list. We have not heard from law enforcement in the last 12 years that there's been any issue at all about concerns about the validity of an out-of-state permit. One reason for that is because permit holders very rarely have encounters with police officers that require such a thing. But different police agencies in different states work differently in the way that they issue these permits. Sometimes there's a statewide database, sometimes it's at the county level. But we have never heard from law enforcement that there's a problem with validating out-of-state permits.
Okay, we've got Representative Johnson, and then we'll probably bring some more testifiers down.
Mr. Chair, members, we keep coming back to the issue in North Dakota of the two-tiered system, two different Class 1 and Class 2. What I heard in the testimony is the Class 2 is not valid in Minnesota. It doesn't meet the requirements. It's not an issue. Class 1 would technically, but if this bill passes, meet the requirements. So only a Class 1 license would be here. And what Representative Hillstrom read, you can't get a Class 1 unless you're over 21, so that's not an issue. I think some of us are looking too deep into this, trying to find technicalities. This bill requires DPS to go through the other laws, look at it. Are they similar? Do they require training? Do they require background checks? Okay, they do, so we're similar. We can go along with this. But what we're not talking about is the way to protect our citizens when they travel to their states. Because it also allows our citizens who've gone through these background checks to actually carry in their states, to protect themselves. There's some states that I've been in as a peace officer. I made a wrong turn. Got off the freeway at the wrong exit. And I did not feel safe there. And I had my family with me. I got out of there as quick as I could, just because I made a wrong turn. But if something like that, our citizens of Minnesota wanting to protect themselves in these other states that we have this reciprocity with, it gives them that ability.
Okay, Mr. Rothman's short comment. And then Representative Schoen after that.
Representative Johnson, Mr. Chairman, members, Representative Johnson is correct, and it's worth pointing out that the history of the Class 1 permit in North Dakota, it was created out of a frustration with Minnesota's recognition or non-recognition of the North Dakota permit. And in fact, the North Dakota legislature created the Class 1 permit in North Dakota, modeling it directly after Minnesota's permit to carry law for the express purpose of gaining reciprocity with Minnesota. And it was very frustrating for North Dakotans and Minnesotans alike that even after North Dakota's legislature followed the instructions from the Minnesota DPS in creating a substantially similar law, that it was decided by the DPS that it wasn't substantially similar. This bill would fix that problem, and as Representative Johnson said, the larger issue isn't that some people from North Dakota are able to carry when they come to Minnesota, but that Minnesotans are able to carry when they go to North Dakota, when they go to Florida, when they go to a number of other states that currently we're not recognizing and thus won't recognize us.
Representative Schoen, and then we've got Representative Schoen, Representative Considine, and Representative Hillstrom in that order. Go ahead, Representative Schoen.
Mr. Chair, all I'm looking for is a yes or no answer on this particular question, because I feel like I'm getting mixed signals now. This started with North Dakota. The permit, whichever class it is, for North Dakota residents that are 18 to 21, if they get the permit to carry, will this allow them to carry in Minnesota? Can I appreciate your, can research tell me, yes or no, will this allow them to carry in Minnesota?
First, research. Go ahead, Mr. Gavel.
Mr. Chair, Representative Schoen, members, the statute still permits the department to exercise their judgment on which laws are similar. I don't think the language that's proposed in the amendment would make it compulsory that they recognize a Class 2 permit from North Dakota, but I can't say with certainty what the commissioner would do.
And then Mr. Rothman, if that's okay, Representative Schoen.
That's fine. I mean, that's a question I'm going to, when DPS comes down, I want to make sure they put that on their list as a, just answer that, yes or no. That's all I want to know.
Okay. Mr. Rothman, could you, and then we'll give DPS a shot later, too. Go ahead.
Mr. Chairman, Representative Schoen, members, to the best of my understanding, not being an attorney, the amendment requires proof of firearm training or proficiency. And if the DPS were to look at the Class 2 permit, which doesn't require any firearm training other than taking an open book test, they could determine that that was not firearm training or proficiency. The Department of Public Safety could then say that while a North Dakota 18-year-old Class 2 permit is not valid to carry in Minnesota, that a Class 1, nearly identical to Minnesota's, is.
Okay. Where are we at now? We've got Representative Considine and Representative Hillstrom.
My question is for Representative Johnson. Realistically, how many guys in your department know that there are two different licenses in North Dakota, and if an 18-year-old flashed a permit to carry, would they even question it?
Representative Johnson.
First of all, right now, they would go to the website to see if we have a reciprocity in North Dakota. If they did not, the person would be cited for carrying a firearm without a permit.
Representative Considine.
The question is how many of your coworkers would actually go through that if they were shown a permit to carry the two? Would they not just assume that it was valid? And, you know, I understand that this causes some speculation, but my guess is the vast majority of in your department, in my former department at Blue Earth County, that if they saw this, they would just go, okay, they've got a permit to carry. It's speculation.
Yeah.
I'm asking for some speculation on Mr. Johnson,
go ahead.
or Representative Johnson.
Just speculating, the first thing they'd do, they'd take that permit, they'd just secure the firearm at first, make sure everybody's safe, take the permit, go to their squad car, go to the website. First of all, see if we have reciprocity. If we have reciprocity, they'll double check it, and they'll do some inquiries the best they can to see if the permit is valid. I myself have never run into a situation where I've stopped somebody that was from another state that, in fact, I don't believe any one of in our department has ever stopped anybody from out of state that dealt with a firearm. I'm only aware of one situation where it was a person the local person who did some very poor judgment, and he did have a legal permit, but he decided to show the officer his gun, which made things very tense. But as far as the out-of-state, I'm not aware of ever running into a person with them.
Representative Considine.
I would just say that you have a very diligent department then that would go through all those steps.
Yeah, I mean, as chief of police, my officers better dang check. If they see somebody with a handgun, they've got a handgun permit, I think every single one of them in Blue Earth County probably would too. They want to make sure that guy's got or woman has a valid permit. And I don't think they just allow a flashing of a permit any more than they would the flashing of a driver's license. So where are we at now? Representative Hillstrom.
Thank you, Mr. Chair. Representative Johnson, this is a question for you, Mr. Rothman, but Representative Johnson said that by adopting these other states' permits, that other states will recognize ours. Is there anything in this statute that requires that if we say they're substantially similar, they're similar, and we're going to adopt them, that requires the other state to recognize ours? Don't they have the ability to set the standard on whether or not it's substantially similar or whatever?
This is for who?
Mr. Rothman.
Mr. Rothman, go ahead.
Mr. Chairman, Representative Hillstrom, members, that's a great question. There are 50 states, and they have 50 different sets of standards in their laws as to which states' permits they will recognize and with which states' permits they will achieve reciprocity. In some states, such as Missouri, they simply recognize any carry permit from any other state. So they don't care what we do. They recognize any carry permit from any state. Some states, like Florida, are strictly, will recognize you if you recognize us. And so even though our training standards are certainly at least as strong as Florida's, they will never accept ours until we accept theirs. And so I'm not saying that every single state that we accept will accept ours, but that is the rule rather than the exception. Most states that we recognize will in turn recognize our permits. The existing law from 2003 also requires our state to execute any necessary reciprocity agreements to cause that to happen. But of course, Minnesota law can't compel another state to recognize us.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. Mr. Rothman, so then if any state can recognize Minnesota's permit, whether or not we recognize theirs, how many other states have recognized ours? We recognize, you said 11. How many other states currently recognize ours?
I don't have the exact number, but it's in the neighborhood of half the states in the country.
So, Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. So, Mr. Rothman, so you would agree then that the other states at least believe that Minnesota's process is at least as good as theirs or better. Is that correct?
Mr. Rothman?
No. Different states use different standards for recognition. Some of them don't look at the other state standards. They simply look at whether we recognize theirs. Some recognize all of them. And so this comparing of standards is used by some states, but not all of them.
Mr. Chair.
Representative Hill?
Thank you, Mr. Chair. And so somewhere, Mr. Rothman, do you have a copy of what every other state standard is that I could look at?
Mr. Rothman?
There are websites which list every other state's, I'm sorry, Representative Hillstrom, Mr. Chairman, a list of which states they currently recognize or the process for recognition?
Mr. Chair.
Representative Hillstrom?
Thank you, Mr. Chair. I'm looking for the standard that they use, because what you're talking about in this bill is changing the standard, right? Minnesota right now uses substantially similar, and you're proposing that we go to similar. And so my question is, do you have a website or a document anywhere that looks at what other states use as their standard for evaluation of Minnesota's permit?
Yes, the website, Mr. Chairman, Representative Hillstrom, members, the website handgunlaw.us is a volunteer-run website which tries to be a comprehensive clearinghouse for 50 states' laws. We've seen in Department of Public Safety documents that they often look to this site for information. I'm at that website right now through the miracle of modern technology, and we can see that if you have a Minnesota permit to carry, that these are the states that currently recognize. The Minnesota carry permit, and as you can see that North Dakota is a really, really big red spot for folks who live in Minnesota.
So, Mr. Chair.
Representative Hillstrom?
Thank you, Mr. Chair. So red spots mean they do not recognize, blue spots mean that they do? Is that what you're telling me?
That's correct. If I want to go to Disney, Mr. Chairman, Representative Hillstrom, if I want to take the kids to Disneyland, my Minnesota permit is not valid in Florida.
Okay. Now, should we bring DPS down now?
That'd be good.
And, what, Representative Newberger?
Thank you, Mr. Chair. In all due respect to Mr. Rothman's technology, I'm the old school guy that I am. I got this handy card when I took my permit to carry class, so if you would have asked, I would have showed you.
Okay, we're not ready for you yet, sir. You can go ahead. I'd like to have DPS come down. Representative Rosenthal.
Thank you, Mr. Chair. And this is a question for Mr. Rothman. That's a nice picture up on the wall. Can you tell me how many states currently recognize North Dakota's permit?
I believe that we can make the website do that. I'm reliably informed, Mr. Chairman, Representative, I'm reliably informed by my old school colleague that the number of states recognizing North Dakota is 38.
Okay. DPS. You guys can make room for DPS there.
I don't think we need to. I'm happy to come back.
Commissioner, did you plan on testifying or just answer questions?
I'm just going to give a brief statement, sir, on the position of the department, and then I'll Mr. Newton can answer questions.
Name and title, and go ahead, sir.
Mr. Chairman, Mark Kanaski, Deputy Commissioner, Department of Public Safety. We just got the amendment last night, early this morning, took a look, and we're still kind of going over it. We do appreciate Representative Hillstrom's amendment, I think, which helps clarify
wherever we're at, and if we aren't done with DPS, we'll just have them come back after session. And did you have any others? We'll take questions.
No, Mr. Chair, I guess my concern is if there are members of the public who can't come back later tonight who would like to testify. I'm sure DPS is prepared for deadline week, but members of the public might not be, giving them an opportunity to speak.
We're going to recess at noon, and hopefully they can come back.
Mr. Chair, could the commissioner repeat what he said, because I think the system got turned off, and I'm not sure that was on. I don't think what he said was on the record.
Oh, Commissioner, go ahead. Restate what you said. Which part? The whole thing?
Well, especially the part addressing my concern about the subjectivity of the Class 1, Class 2.
Commissioner.
Mr. Chair, I won't go through the whole statement again. And again, we just got this amendment this morning, and we're still interpreting and looking at it. But as we read it, it's very clearly defined. It takes the subjectivity out of the term similar, because it's very narrowly defined in number 1 and number 2 on here, what you have to have to qualify or to be similar to the state of Minnesota. And so as we were looking at this and listening to the conversation about going back to North Dakota, not to focus on that, but North Dakota, understanding that they do have the Class 1 and trying to accommodate Minnesota's current regulations. As was explained here today, an 18-year-old, by virtue of the fact that they did take a test and they had firearms training, could arguably carry in Minnesota.
But I'm wondering why you would interpret it so loosely now, because if they didn't take, my understanding was in one of those classes they didn't have to take the range training, just a test. Is that correct? And so if they didn't take range training, they just took an open book test, you could still, even with the change in the law, restrict them from being acceptable, right?
Mr. Chair, Joe Newton, Department of Public Safety. The way that similar is now defined in this amendment, the department would only be able to look to see if there was a NICS check and or a mental health background check. Because it says for purposes of this section, governing the issuance of permits to carry shall be considered similar provided that. So when you look to the training and other issues, very arguably we would not be able to take those into consideration. If the individual state did the NICS check.
You got to turn the page over, I think. On the back it says they have to demonstrate
right, and the proof of
training.
But we also look at a number of other issues. We look at chemical dependency, we look at mental health issues, we look at certain crimes of violence and other things. Our amendment arguably would just look to whether they do a NICS check and whether there's training.
But you could disqualify them if you wanted to because of the training, lack of training.
Because of the training, Mr.
So you
Chair,
wouldn't have
yes.
to worry about all the other stuff.
Mr. Chair, yes, sir, that's correct.
Okay.
Mr. Chair, could I ask a qualifying question or a follow-up question on that point? It says training to the satisfaction of that state's laws. So as long as that state, even if it's just an open book test, if that's satisfactory to that state, Minnesota has zero discretion under this law or this proposed law to consider whether that training would be adequate for Minnesota's purposes. So if open book is good enough in one state, it's good enough in Minnesota.
Either one?
Mr. Chair, Representative, that's correct.
Okay. Anybody else? Representative Quam.
Thank you, Mr. Chair, and having sat through years of testimony in education committees, according to our education area, testing is not training. And I think you probably have seen a lot of correspondence from constituents hammering that same point. Testing is not training.
Okay, Representative. Any other questions? Okay, anything else from DPS? Sure. All right, thank you.
Mr. Chair?
Yeah.
Before they leave?
What's that?
I have one quick question before they leave.
Yes.
Thank you, Mr. Chair. You referenced addiction, domestic assault, and other types of crimes or issues that might allow people to carry firearms under this current bill language. Is that correct?
Mr. Chair, Representative, yes, we would, under this bill, we would look to just the training and whether there was a NICS check done and or the requisite mental health.
Okay, is Sheriff still, did you want to say anything, Mr. Franklin, or were you on the list or anything? Or? And then yours will be the last, and then we'll recess. And then everybody's welcome to come back 15 minutes after session in the basement hearing room.
Mr. Chairman, Jim Franklin, Executive Director for the Sheriff's Association. We just got this this morning, so my comments are just personal. They're not reflective of the sheriffs. They just have not had time to respond back. I was with Mr. Olson in 2003. We've worked together, done a good job to get us to where we are. I think we need to look at what we have in place in Minnesota and compliment the people who have done the training. With our statistics and what has happened, they've done a good job. And I think it's partly because of the collaboration and the system that we've brought together. You see how many questions there are with regards to this. We do, on a national basis, have an issue with how many mental health records are put into the NICS system. I will tell you, as I travel around the country and meet with my counterparts, that is a flaw. I agree, we need to get them in there. We're not quite there yet, but we need to keep working that direction. So if I had any suggestion at all, we worked several years back in 2003 to get this together. I think there's some very important points on both sides of the equation here. I think we need to put a work group back together again and come back and find some common ground where we can expand the current usage and look at this, because I think we can look at it. We've got 10-plus years, 12-plus years history, and I think it's been a positive history, and I think we can learn from that and do better.
Okay, with that, members will come back at 15 minutes after session, and I will give the DFL side plenty of time to get back. We're not going to take any votes without all of you folks here. And same here, if my GOP members could make sure they have their places in their seats at 15 minutes after session, I'd sure appreciate it. Meeting adjourned, or excuse me, meeting recessed until 15 minutes after session.